All right, I'd like to welcome everybody to our webinar. Today is, let's see here, what we're looking at, the 7th of April. So I'd like to welcome everybody to the SBDC webinar. Today our topic is steps to IP management strategy. Just a little housekeeping here. If you do have questions, please put them in the chat box and they'll be answered. If not during it, they'll be answered at the end of our presentation. We usually go for 25 to 30 minutes. And next week's topic will be understanding business cash flow and financing options. This is an exciting topic that every business out there needs. We're excited to have some new people, looks like, on our webinar today. We, this week, got a report of all the people that are listening to them on our website, and we're excited. We didn't think that many people was listening to them if they can't join us, but we have quite the following of people every week logging in to listen to these even after the fact. But we're excited. We've got a great presenter today. Mr. Paul Cooper-Ryder is out of our Boise office with the SBDC. And he's going to be presenting today. Like I said, keep your questions, put the questions you have while you're going in the chat box, and we'll try to get to those after. And with that, we will turn the time over to Mr. Paul Cooper-Ryder out of Boise SBDC office.
Thank you, Brian. Good morning. Can everyone hear me?
Sounds good to me.
Okay, great. Well, as Brian mentioned, my name is Paul Cooper-Ryder. I am the Technology Commercialization Program Director for the Idaho SBDC. I'm also the coordinator of the SBDC's technology team, or tech team. And what we do is we provide unique services to technology clients that we wouldn't provide to your normal client. We have 4 areas of specialty. We have expertise in product development and prototyping. We have expertise in alternate funding other than bank loans. And we have expertise in go-to-market strategies for disruptive and new technologies. And finally, we have expertise around intellectual property management. And that is the topic that I'll be talking about today. So, the first thing you may ask is, why should I care about IP management? Well, the reason you should care is because a properly managed IP portfolio will provide you with better revenue, better profit, and better company valuations, and ultimately lead to the success of your company. So how does IP management deliver these benefits? It delivers them through 2 channels. One is by providing monetization potential, and we'll talk about multiple ways that you can monetize your IP. And also provides benefits by attracting investment, because most investors will place value on a company's ability to monetize its IP. So let's talk a little bit about monetizing and attracting investment from your IP. The first way that you can monetize your IP is providing what we call a durable competitive advantage in creating and delivering your value proposition. Primarily, that's done through means of protecting and enhancing your revenue streams and your profit margins. And that's often manifested in terms of higher incremental margins or reduced cost of goods sold. Other ways that you can monetize your IP is leveraging it for building alliances and partnerships. And finally, you can license it or sell it outright. If we look at attracting investment, IP is an integral part of the valuation of a company. And it's an important part of valuing a company when you're looking to investment during your funding rounds, and especially critical as part of the valuation of the company when you have an exit event such as a merger and acquisition, an IPO, or liquidation. So let's look at some examples on how you might monetize your IP portfolio. First of all, let's look at protecting and enhancing your revenue streams and profit margins. In this example, and these are all real examples, in this example, Company A has a patent on a CPU bus bar architecture. Because of that patent, they became the de facto sole source supplier, and as a result were able to charge a higher price to their customers. On the flip side, they were able to license that technology to their suppliers and leveraged it so that they could get a lower cost of goods sold from their suppliers. So they benefited from both revenue and a lower cost of goods sold. Let's look at licensing. Qualcomm has a bevy of patents that is used in smartphones, cell phones, etc. And they derive most of their revenue from licensing. So in 2016, Qualcomm received $7.6 billion of licensing revenue, and of that, $6.5 billion was pure profit. Now, the same Company A above was able to sell their patent portfolio of 50 patents for $100 million on an exit. So that's the example of selling your IP outright. Let's look at leveraging your IP for alliances and or partnerships. In this example, Company B had a portfolio of patents that were included in an industry standard for storage products or family of storage products. Because they had this patent portfolio, they were able to influence the standards body on the format and the things needed to create that format. And as a result of that, they had first mover advantage in the supply chain for creating that necessary format. If we look at valuation of the IP portfolio, in this example, Company C was looking to buy a software company for $5 million. But in their due diligence, they found that the seller did not own the copyrights to the code, and consequently, the deal cratered. Conversely, a properly protected and recognized IP portfolio can boost the IP valuation by 5x to 7x. It can affect an exit valuation by millions of dollars. And this is from an IP attorney here in Idaho that has a healthy practice. So now that we've seen how IP can provide you the benefits, how should you manage your IP? We at the SBDC utilize the same framework for managing IP as we do for creating the framework for counseling our clients. So we use the business model canvas, lean launchpad processes. And just as a quick reminder, on the right side of the business model canvas, we want to make sure that you have clearly identified who your customer segments are and that you were able to provide a value proposition that meets the pains and gains in your customer segment, thereby creating what we call product market fit. So once you have product market fit, then you can see how IP as a key resource can help you create and deliver that value proposition. And that's what we spoke to in the slides above. Now we're going to talk about the other blocks, a couple other blocks in the business model canvas, key partners and key activities to create and protect your IP. First of all, we're going to talk about key activities. So there are 4 main key activities. One is to explore your freedom to operate. Second is to inventory the IP in your portfolio. Third is to identify the gaps in that portfolio relative to what is needed to protect the creation and delivery of the value proposition. And that's the focus of this whole process, is to make sure that you are protecting the creation and delivery of your value proposition. And finally, how do you own that necessary IP? Do you develop it or do you acquire it? So the first of those 4 activities, you should be asking your company, how does your company have the freedom to operate in your market segments? You may need to look at your competitors' IP, look at their patents, their trademarks, their copyrights, their domain names, etc. And you can do this through preliminary searches and landscaping. You can utilize tools from the U.S. Patent and Trademark Office or online tools like Free Patents Online or Google. You can also utilize the University of Idaho's Small Business Legal Clinic. This Small Business Legal Clinic provides assistance in trademark and patent prosecution through their pro bono programs. Once you've determined that you have sufficient freedom to operate, you'll want to inventory the IP in your portfolio. And that means that you want to inventory the patents, trade secrets, trademarks, copyrights, domain names, etc. And the first thing you'll want to do is to assess the strength of your IP in protecting your value proposition. One of the things you'll want to do is to understand the ease of work around your implementation. If you believe that a competitor can find another way to work around your implementation with relative ease and without violating patents, you may decide not to patent because that's essentially not a good blocking mechanism. You'll also want to take a look at the ease of reverse engineering. And this is important in terms of determining whether you should patent or whether you keep it as a trade secret. If you decide that it is difficult for someone to reverse engineer your solution, you may decide to either patent a little bit or not at all and keep it all as trade secrets. If you decide to treat your IP as trade secrets, you'll need to go through the processes essentially that would be recognized by a court of law as protecting your trade secrets. We'll talk a little bit more about that later. Now, if you decide that your patents, trade secrets, and copyrights are insufficient to protect your value proposition, you may choose to use a branding strategy. To establish your brand identity, you'll have to undergo a process to define and gather your trademark, your trade dress, and domain names. And of course, this is going to be integral with your go-to-market strategy. Once you've inventoried your IP, the next step is to identify the gaps, again, relative to what is needed to protect the creation and delivery of the value proposition. And the question you'll need to ask is, where does my company need to have IP to protect that value proposition, but it doesn't have it today? And again, you'll have to go through some sort of IP landscaping to identify where those gaps exist. Once you determine where those gaps are, you'll want to ask, what's the most effective way to own that IP? And there's generally 2 channels. You either develop it by building it or creating it, or you acquire it through either a license or cross-license. If you choose to build and create your own IP, you'll need to understand timelines around patenting. You'll need to understand concepts like first to file, which puts the U.S. in alignment with the rest of the world. You'll need to understand that you have only 12 months from the time that you first make a public disclosure of your invention to the time that you need to file what's called a non-provisional patent application. And you also need to understand the timelines of various activities and maintenance fees after you receive a patent. Should you choose to go international, You'll need to understand how patents work internationally. You'll need to have some way of estimating the timelines of the timing of when you would receive an international patent and when you would enter the market internationally. You'll need to understand the costs and timelines of the individual countries and whether you can use the Patent Cooperation Treaty or the PCT option. You'll also need to understand the role of the USPTO and the World Intellectual Property Organization, WIPO. Should you develop trade secrets, what you'll need to have is demonstrated behavior that you can uphold in the court of law that shows that you've been diligent in protecting your trade secrets as such. You'll need to have proper NDAs, you need to have proper employment agreements, and you need to demonstrate that you have both physically and digitally secured the documents. Should you decide to go the route of branding to protect your value proposition, you'll need to determine the process for establishing your brand identity, again through the use of trademarks, trade dress, and domain names. You'll also need to understand the difference between the TM as a marker of trademark and R with a circle for a registered trademark. One of the things that small companies overlook is the importance of domain names. Getting domain names is not that expensive, and it's fairly important that you should consider creating a moat around your brand identity as demonstrated by your domain name. The last thing you want is for a competitor to create confusion in the marketplace by using your domain name and then using .net or .us versus your .com. And again, if you choose to do branding overseas, you need to understand the timing to achieve the brand identity versus your market entry and the role that USPTO and WIPO can play. Should you decide to license or cross-license, again, you'll need to understand what the IP landscape looks like, and in particular, who owns the rights to the IP that you need. Once you determine that, you can determine whether you want to license or sub-license. And in some cases, where there's an opportunity for cross-licensing, you'll need to determine whether your IP war chest is big enough to make it attractive for cross-licensing. When you get into the details around licensing agreements, you'll need to understand concepts like foreground and background IP. Background IP is the intellectual property that your company owns independent of any collaboration with an entity where IP rights or IP is used. Foreground IP is intellectual property that is generated as a result of that collaboration. And there are certain terms that need to be determined and put down in a legal document to determine how those rights are used. You'll also need to be familiar with terms such as field of use or field of use restrictions, the territory over which that licensing agreement holds, the duration of that agreement, and rates such as licensing fees, royalty rates, etc. You'll also need to understand terms like warranty and indemnity inside those licensing agreements. So that covers the key activities needed to create and protect your IP. Now we'll talk very briefly about the key partners. Key partners can be bracketed into 4 categories. The first is your IP attorneys, patent agents, IP clinics. These are the entities that will prosecute your patents, your trademarks, etc. The second grouping are entities like the USPTO, the U.S. Copyright Office, and the World Intellectual Property Organization. These are organizations that would actually grant those rights or coordinate with the bodies in the relevant countries to grant those rights. The third group are consultants and mentors, including the SBDC, that have experience in managing IP, but are not attorneys or patent agents. And finally, the fourth group are investors. Especially investors in technology companies recognize the value of IP and will help you manage it to derive the maximum benefit as well as maximum valuation. And that concludes my presentation. I am now open for questions.
Paul, so on this, can you, I mean, does it always have to be a physical, tangible product, or can your intellectual property be a process that you're doing things? I mean, you know, like a process that you have involved in your business. What all is considered intellectual property of a business?
So, software is not a tangible product, but software is viewed as intellectual property. Trade secrets are often not necessarily tangible. For instance, I'm going to use Micron Technology. Micron Technology, you know, is a huge company, but a lot of their intellectual property is tied up in their trade secrets in terms of how they manufacture their devices. So their competitive advantage in terms of getting very high yield, low cost, high quality is really wrapped around their portfolio of trade secrets and their processes for making those devices. Again, not tangible, although the solution they deliver is tangible.
So,
does that help?
So how do you protect that kind of stuff? I mean, if you have employees that are in there seeing you doing all this stuff, how can they not go out and duplicate it and you be able to sue them?
So this slide here, when I say demonstrated behavior, that's part of the employee agreement. So every company, every technology company, I would recommend that they have an employment agreement with every one of their employees. And in that employment agreement, you would have a couple things. You would have the assignment of all intellectual property that employee generates is assigned to the company. That's very typical. And the second is some sort of clause or paragraph or section that covers the management of IP, that makes it the employees responsible to treat the company's intellectual property as company property and not violate it, not take it out, not communicate it, etc. Keep it confidential.
Okay. When a company sells, how much of the blue sky that's based into the company when you sell a company is based on intellectual property? I mean, what usual percentage? I guess it depends on the type of business that it is, but it seems like that the more you can put into intellectual property, the more value you should be able to get for your company.
In general, that's true. What you said is also true. Is that depends, because if the intellectual property is primarily like in software, and you are selling that company, they're going to take a really hard look at the value of that IP.
Yeah.
If in other words, we're trying to think of the example. I mean, let's pick Micron as instance. They have a huge portfolio of patents as well as their trade secrets, and so a lot of the things that a semiconductor industry or a semiconductor company might do is not necessarily unique outside of the IP that they have. So you can look at the plant and equipment that you have. You can assign value to the plant and equipment, but in the long-term scheme of things, because of the depreciation of plant and equipment, the value of that company, of Micron, is primarily wrapped up in its intellectual property and its know-how and the people that exercise that know-how. not in the plant and equipment, because over time that will depreciate and have less and less value.
Yeah. Good. Any other questions out there from any of our people? Write them in to the chat if you have or if you have a microphone, go ahead and turn on and ask any questions you might have. We've got a couple minutes left here. If anyone else has any questions, I think that this the understanding what all is considered intellectual property is one of the golden questions that that a lot of businesses struggle with. So I'm glad that we were able to learn a little bit more about what all this consists of intellectual property. So
yeah,
there's another question. Go ahead and look in the chat box there.
Okay, I got a question from Sonia that says, how does one know if a product is worth patenting, i.e. the Paul Washer product? I'm not familiar with the Paul Washer product, but typically when this is a question that will probably require assistance from either an agent or a patent attorney. You can go ahead and you can do some preliminary searches on your idea and see if there's something called prior art. Prior art is any publication, whether it's patent or whether it's white papers or papers in journals, etc., that talks about a specific idea. And you can see whether your idea is the same as what was written in prior art. And if it is, then it's probably not patentable. If you find that there is no patent or prior art out there that talks about your particular innovation, then it may be patentable. But then it's also a question of whether it really provides value to protecting your value proposition. Because we call when we talked about the ease of working around, many times a small company or inventor will have an idea that is patentable, but from a delivery of the final solution, the competitors can find relatively easy ways to work around that patent. In other words, the patent is what we call narrow. It's very focused on something. And there are ways to work around that particular focus to create a very similar solution for the customer. So in that case, although it is patentable from a practical standpoint, you may choose not to follow that path.
Good. That's a great question. That it sounds like there's an unfortunate situation there with Sonia. But do you have any over here in Idaho Falls? We have an attorney that focuses on patents and trademarks and that kind of thing. I think her name's Tally Russell. We've had her do some presentations here with the SBDC. Do you have anyone that you might recommend over there in Boise area?
There's several of them, or I should say there are a few of them that I could recommend. I think just for relationship standpoint, if people want to contact me and ask me for those names, I'll do that. But I want to remain fairly neutral, so I'm not going to give out names publicly in a broad audience like this, because we have to maintain our relationships with various legal firms here in the Treasure Valley, and I don't want to have any vision of favoritism.
Biased yet? Did you want to put your contact information back up?
Sure.
Oh, very last tag.
I did that.
All right, there's Paul Cooper Ryder at boisestate.edu is the email there. So thank you so much. Great information, Paul. Appreciate your preparation and your execution of this webinar. We will have this up on the innovateidaho.org website here either today or first thing on Monday. Paul, thank you so much again. Great information here. So thank you, everybody. Next week's will be on understanding business cash flow and financing options. This lady that's going to be presenting is extremely qualified in QuickBooks and has worked with a ton of companies on helping them with their finances. So this will be a great webinar next week. Thanks again, Paul. Everybody have a great weekend.
All right, thank you.